Justin, thank you so much for this and all you've done for the program. Welcome all. Forgive a quick and painless Berkeley Judicial Institute advertisement. Whether you're here for the first time or you're one of our cherished regulars, we'd love to see you back. Check out our website where you can register for future programs, watch recordings of past programs, find interesting things to read. Consider joining our mailing list or following us on social media. Advertisement over and on to our main event. I will so briefly, like if you pause, you'll miss it, introduce our stunningly distinguished faculty, and you can find their links to their professional resumes in the chat, thanks to my colleague, Justin. So we'll hear today from Anna Russell, who's Deputy Director and Adjunct Professor of Law at the Cornell University Law Library. Not only is she faculty for today's program, she suggested that Berkeley Judicial offer this program after being wowed by her fellow panelists. No pressure there, fellow panelists, who are Michael Lissner, who's Executive Director and co-founder of the Free Law Project, and Brian Carver, who is a board member and co-founder of the Free Law Project. So with that as an introduction, let's get to it. Professor Russell, where will we start today?
Hello, everyone. I'm really happy to be here. I see some old and some new friends joining me today. So without further ado, I'll just dive in. One need only do a quick search to easily find recent conferences and reports from government agencies, bar associations, nonprofits, and academic institutions detailing how we got into this access to justice crisis, as well as the many varied reasons why the majority of US citizens cannot obtain representation or forego the justice system entirely. The Legal Services Corporation most recent Justice Gap report states, low-income Americans did not receive any or enough legal help for 92% of their civil legal problems. Nearly one half of those who did not seek legal help for one or more problems cite concerns about cost as a reason why. So today we're discussing a major component of why legal help is so costly. It involves legal information and technology. We're calling this the data to justice pipeline. And the key takeaway from today's program is that when we make legal data more accessible, it lifts the whole legal information ecosystem up. Next slide. In hopes of creating a general picture of the state of access to legal information, we need to think about the reality of legal tools juxtaposed with the ideals we all hold about the legal profession. We all want the justice system to be a level playing field where justice is blind. But when we have locked legal data into expensive silos where only select members of society have access to the tools, the skills, and the system expertise, we are decoupling our best ideals from our data reality. Next slide. In thinking about legal data, it's helpful to reflect on some major shifts in the legal research process over time. Access to legal research has become so lopsided that it's hard to grasp from an outside vantage point. The one who can afford has no idea what is available for free and vice versa. Most in the legal profession may forget how legal research used to work in the past via books and shepherdizing. I mentioned the print book legal research approach to make a couple points. My first point is about the equality of time, no matter the cost. The research process itself could be equally as time intensive for the novice as for the experienced team of litigators. My second point is about the shared access to the same legal resources. Books were often co-located for opposing parties, self-represented litigants, courts, and so on. All types of legal researchers use the same database, so to speak, which was the law library. A final important but often overlooked point has to do with the legal information ownership model. In the print days of legal research, the established partnership between the commercial legal publisher, the courts, the law library, the legal professional skewed through contract terms in favor of the needs of those using the print materials. Hence, this commercial user relationship in the law was often seen as symbiotic. Fast forward to now, I don't have to convince you how unequal access to online legal information has become because you have likely hit your own paywalls when it comes to legal data. The siloing of legal information is extreme because the data is packaged in ways to reduce the time spent on any one research task for those who can afford it. The more you can afford, the faster and the more legal information you can subscribe to. Next slide. This sentence is our legal ideal. I assume we all agree. It's absolutely awe-inspiring to stand outside the US Supreme Court and see the words equal justice under the law. Today, we are talking about the data to justice pipeline because we do not want these words to become hollow. Next slide. Legal research innovations need open data. Recall the point I made about the print book relationship with commercial legal publishers. It never occurred to most in the legal profession how this contractual relationship would change when we moved from print to digital legal information. This publisher user model that had users owning books that they purchased and libraries could lend books for free was flipped on its head. In the digital environment, we see contracts being pushed aside for subscriber term licensing agreements. The balance of the data power shifts into the hands of the commercial entities who own the legal data. I am certainly, I use digital legal research all the time. I'm very much in favor of it, but we must acknowledge the new challenges and consequences that came with online legal research. So, okay, fine, but who owns primary laws? And by primary laws, I refer to cases, statutes, regulations, and local codes that flow from federal, state, tribal, local, municipal jurisdictions. At this moment in time, I truly think a realist would say the big commercial legal vendors own primary law for three major reasons. The first reason is because of the editorial features and citator tools that are critical to evaluating primary law. Secondly, they own primary law because they contract directly with the creators of primary law, like legislatures or court systems, and they receive data first. This sets up a middleman relationship for useful access to primary law data. This close relationship also means that creators of primary law will contact commercial vendors directly to make sure that primary law is correct within their commercial systems. I also think that through this close relationship, we are stuck using the concept of a national print-based reporter system, even though I do not know anyone who purchases print reporter books anymore. It's an outdated mechanism for reading case law from an earlier time. The third reason commercial companies own primary law is because any new legal research startup has to pay to play. Has to pay the commercial vendor to compete with that same vendor, and the commercial vendor can choose not to sell the data. Okay, so if I painted this bleak, realistic picture about who owns the primary law reality, it's also true at the very same time that the legal ideal reminds us of the public policy doctrine called edicts of government, which the United States Copyright Office acknowledges, stating that edicts of government, such as judicial opinions, administrative rulings, legislative enactments, public ordinances, and similar official legal documents are not copyrightable for reasons of public policy. This applies to such works whether they're federal, state, local, as well as to those of foreign governments. So does it matter who owns primary law? I think it does. One only need look at the current system to find lopsided research access between big and small or solo law firms. I'm not even mentioning the gulf between the self-represented litigant and the legal professional when it comes to digital legal information access. This access to justice problem is not new, so why does it matter more now? Because of the elephant in the room. Next slide. Generative AI in the legal field uses retrieval augmented generation AI models, or RAG, legal tools, which are new in their infancy. And they're in their infancy. The time savings that attorneys already see from these brand new RAG models is both awesome and scary. The possible innovations in large scale legal issue trend analysis are really exciting. Currently, however, these new tools come with a high cost and very limited access. If we agree that it's crucial for the legal system to move in the direction of a level legal playing field, we need to find a way to make large sets of primary law data free so innovators can develop affordable, high fidelity RAG legal models that are available for the use of all of us. We cannot expect the research costs to come down in an environment where the primary law modeling data required to support these tools is unavailable to legal tech startups at affordable pricing. We also need to appreciate the lack of transparency that results when only the haves use these high-powered AI-driven models. At present time, RAG AI legal models can easily overpromise on jurisdiction coverage because it's all black box. We have no checks and balances because we have no public legal data research systems that allow us to verify how our legal systems are dispensing the rules, orders, and opinions. Next slide. Hopefully, I can quietly slip in my new concept of primary law data plus. However, while I've been presenting, some listeners may have had the thought that I have left out the fact that many primary law creators provide free primary law in various government websites around the country. Yes, I did leave that out. You are very correct. None of these primary law authors, though, are comprehensive or provide robust search tools or a free case citator. There are many reasons for this point. Primary law creators also have to manage large systems for producing laws. Free lists of primary laws, though, will never be enough to level the playing field. And it is true that along with the official sources, there are many nonprofit portals, including Cornell's own Legal Information Institute, which provides free access to areas of primary law. Incidentally, about 1 in every 10 Americans over the age of 15 visits the LII website every year, which speaks to this need. I also want to give credit to the many judges, attorneys, academics, legal technologists, public advocates, and law librarians that are working on the truly complex task of making primary law data freely available in a meaningful way. I'm going to set you straight now on the complexity of this task by turning the floor over to Brian and Mike, which is my strategy to make them do the difficult explanations. I am happy to be able to introduce the work of Free Law Project and what they have done to both make case law free and then to make case law available in meaningful ways with free search features and a free citator system. I cannot overstate the complexity of making primary case law freely available, complete, and useful through a free citation network that notices current and outdated laws. Brian is going to follow me next and share some of the work of the Free Law Project, but I just want to set his stage and say that he's not doing a database walkthrough. What we are hoping to do today is show what it takes to make free law meaningfully available. Thanks.
I should begin by saying in my regular day job, I'm copyright counsel at Google, but what I have to talk about here doesn't reflect their opinion. Heck, my opinions probably only about 20% of the time reflect Free Law Project's opinions on a good day, right? So this is me just giving you what I've learned from working on this with Mike now 15 years, I think. So let's go to the next slide and talk about what is Free Law Project. It is a nonprofit organization. We got working on this really actually a little bit before 2010. It was the spring of 2010 when we first had something to release to the world at courtlistner.com. But in general, we're doing what Anna said. How did you say it? Make a big data sets of primary law available for free. Yeah, that's what we've been trying to do most of that time. And not just make the data sets available, but as she said, build legal research tools on top of them that make them truly useful. So I'm going to walk you through just a handful of the things that we have done. There's too many projects to even touch on them all, but I will talk about Court Listener and the recap suite. I probably won't have time to talk about bots.law, so just to say quickly, it's a new thing. You should go check it out because you can follow various bots on the former Twitter or your social network of choice and keep track of some interesting cases with that. But in general, all of our software that we've had to develop in order to make these websites and collect up this case law is also open source and available for people to use on their own, to contribute to, and it does lots of neat stuff. Besides just sort of collect it together, we can find the citations and find bad redactions and get text from documents and so on. So next slide. So the initial problem we set out to solve actually was to build an alert tool for the courts so that you could follow legal developments about a topic or case as they happened. I mentioned I'm super interested in copyright law. I really wanted to be able to know about any new copyright opinion that would come out each day. I had tried and paid for many services that aim to do this sort of thing, but I found them wanting in one respect or another. Many of them were expensive, there's that, but then also often over-inclusive. There's some services that are like, here's everything that happened at the Ninth Circuit today. No thanks, I don't want to know all that. That's more than I have time to skim, right? Then there's other services that are under-inclusive. They would be like, okay, we're going to have some humans write up summaries of the ones we think are most important. But then they're just guessing what I might find interesting or important, right? They're trying to reach a broad audience. I needed it to be personalized to me. I needed really Google alerts for the courts, something that would cater to my niche interest. And that's what we developed at first. Next slide. Both search alerts of the sort that I was describing, and then later came docket alerts. But let me say a little bit about a search alert. There's a copyright case that is over now, but was fascinating. It went all the way up to the Supreme Court and back, that involved the Swatch Group, the makers of Omega watches, suing Costco, the wholesale retailer you may know. And I did a search here that you can't see, it scrolled off, for Omega and Costco, and got some search results back. And if I want to monitor that search and find out when future cases or future opinions start talking about that case, I could push that green button down in the bottom and say, get alerts, right? And then that query would run every day and send me an email letting me know when there's a new opinion talking about this case that I'm super interested in. So that's search alerts, and you can do a lot with that. But then there's also sometimes a particular case that you really want to follow every docket entry that comes on. A fun case in the Bay Area that's raging right now is the city and county of San Francisco have sued the city of Oakland over the name of the Oakland airport, which that's not the name of it anymore. Or is it? I don't know. They're going to fight about it. And so if you are super interested in this case and want to know each journalist in particular, like would find this sort of thing useful, you can push that same green button on this docket page to get alerts for that docket from our recap system, which I'll say more about in a second. So let's talk about recap. It is the word pacer flipped backwards, right? So next slide. let me show you, if you look at the PACER page for that city and county of San Francisco versus the city of Oakland case, and you have the recap extension installed in your favorite browser, then you may see these little blue scales of justice, right next to the docket numbers. That means, that's an indicator to me that those documents are available from the recap archive. And instead of paying PACER, I could click that little scale of justice and get the document for free from Court Lissner in the recap archive. So that's great. It saves you money. And if you install the recap plugin, which if you use PACER, I'm going to insist you do that after this talk is over, then not only will you start saving money, but the documents that you download that are not sealed, it only works on public documents, will also be uploaded to the repository so you can help the next person. So that's a look at recap. Next slide. And I just wanted to point out that I really did mean whatever browser you choose, right? You can add it to Chrome, you can add it to Edge, you can add it to Safari, you can add it to Firefox. It took a lot of work for us to make this thing work across all the browsers. You can find it at free.law/recap. Okay, next slide. I want to turn to the courtlistener.com data set. And here, what I've done is a blank search, just sorted by the most cited opinion, to show you that we have about 8.2 million precedential opinions in the collection in this data set. And the actual number is down in the left in one of these checkboxes that also shows you we have another 800,000 or so so-called unpublished or non-precedential opinions. So over 9 million just in this data set. I keep saying, in this collection, in this data set, because the opinions here are collected largely from the state and federal court websites that we crawl every day and are gathering ourselves. But there's also, we've integrated in some prior collections, such as the Supreme Court cases that Carl Malamud collected a long time ago, and he put online for free. So this collection contains opinions from all the federal courts, the appellate courts of all 50 states, and more, including military courts, tribal courts, specialty courts, such as the U.S. Tax Court. We have a separate collection under the tab entitled Recap Archive that contains dockets and all the documents you typically find on a docket for the federal and circuit courts, basically anyone who uses PACER. While we're here, let's take a look at that first result, Strickland v. Washington, from 1984, the Supreme Court. You may be able to see that we have a line of parallel citations so that we can identify this opinion no matter how someone chooses to refer to it. We've recently been adding many thousands more of these parallel citations, and we easily have the largest open collection of such metadata on the web. You can also note that this opinion has been cited over 100,000 times. And if you're familiar with the opinion, you'll recall it's about ineffective assistance of legal counsel under the Sixth Amendment. So it's often cited in appeals. But when we built our internally at the big legal database providers, which US court opinion had been most cited? We brought this information to light when we built our citation network and published the results. Next slide. So how do you go about building a case law citator? Well, first, you need to make sure you know how to recognize a citation to case law. Conveniently today, they do tend to follow the pattern shown here, so that at least helps define the types of patterns that we want to find within the text of all the opinions we collect. But the details of each of those items within that it's underlined and pointed to can get complex, right? Take just one aspect of this problem, being sure to recognize the reporter abbreviation. In my example, P.2D. Right? You may know that refers to the second edition of the Pacific Reporter, a regional reporter series that collects opinion from states in the so-called Pacific region. And now the widely accepted way to abbreviate it is P.2D without any spaces around the period. But over the years, by prior custom, local rule, choice, mistake, opinions have used a wide variety of abbreviations for the second edition of the Pacific Reporter and every other reporter that's ever been published and of every edition of those reporters. So to be sure to find all the citations, we need a giant catalog of every way that anyone has ever abbreviated every reporter. When we started this effort, there wasn't even an available list of every reporter, much less all the ways they've ever been abbreviated. So we built it, and we put that database online, and we give it away for free. And before we continue, let me quickly follow on something I heard Anna mention, that this particular problem regarding reporter abbreviations is entirely our profession's own making, a problem of our own making, right? The judiciary writes these opinions. They give birth to all of them, but for some reason they let a handful of commercial publishers name them. These opinions are born without a name, right? It seems so tragic. There's typically no canonical way to refer to them when they're initially released. We all have to sit around, wait on a commercial publisher to print some ink on some dead trees, bind them up in a book, and tell us what page number that opinion came out on months later from when the opinion came out, right? I said typically that's how things go because there are a few enlightened jurisdictions that use what are called neutral citations, but I'll let Mike tell you more about that later. Next slide. This is the Reporters DB that you can take a gander at. But right now I'm focused on finding citations to case law, but you can imagine that there's similar problems identifying citations to statutes, to academic journals, and so on. That's something else we're working on, one of the many things I won't have time to talk about. But let's take a closer look at the information about case law reporters. Next slide, sorry. So what's in the Reporters DB is we describe the P series of reporters, we indicate the type of series it is, state, regional, we list off the coverage for each edition, the years that it covered. This is helpful for ambiguous citations where we think there might be an error, and we can say, wait a minute, if that's a case from 1995, there's no way it can just be P, right? That stopped at 31. And so we list off all the courts that are covered by the cases, in this case, around 15 states and a few stray federal cases. But I've also provided you just some examples. There's a giant list in the database of the various abbreviations we've encountered for the P series. Sometimes you get just P with no period. Sometimes you get P with a period, but then a space after. And sometimes you get PAC, period, space, rep, period, right? Something that a human can recognize, right, and understand what's being said. But we're trying to run automated computer processes to identify all these things, right? So we needed this database to find them all. And if I counted correctly, we now have information like this for 1,253 reporters in a file that's over 28,000 lines long. Next slide. So I'm trying to show you a little bit of, boy, there's some grunt work, right? You know, that has to be, this is why this is hard and takes years, to just getting to building the useful tool that you really are aiming for. And what is that, right? What can you do if you have all the citations? If you really go and find them all, then what? Well, you can look back or you can look forward. You can look back on a given opinion and list off all the cases that it cites to. That is, you can build a table of authorities for that opinion. Simple enough. We do that on Court Lissner today. You can also look forward. Once an opinion has been around long enough, it's been published for a while, maybe even has a name, and it's getting cited itself, you can look at all those subsequent citations. We can do that on Court Lissner today. But where the rubber meets the road, the real value of a citator and what people think about when they say that they want one is you can ask questions about how those subsequent citations treat the opinion that they're citing. Is it positive treatment in that subsequent case of my case that I'm interested in? Is it negative treatment? Has it been overruled or is it now bad law? This is what's preying on your mind. Sometimes you also just want to know depth of treatment, right? Like, I need some other cases that discuss my case at great length. I want paragraphs and paragraphs of discussion so I can understand this better and understand how it's been interpreted. So that's another, way of analyzing those subsequent citations. Court Lissner today, as I mentioned, does great on those top two bullet points, and we have some depth of treatment information that's somewhat easier to identify programmatically. But it's that sentiment analysis, the positive, negative, how is this thing treating the prior opinion, that until this age of generative AI that Anna mentioned has been just out of reach for us and that we're going to turn to. So next slide. Just to show you where things stand today, here's an opinion from the Supreme Court that was released in May of this year, 2024. When you're on that opinions page, the screenshot on the left, you can click to see what opinions have cited it in the 5 months since it was released. And there are already some results. Oh, those are actually on the right, sorry. But you might notice that both pages give you some of that depth of treatment information. With the table of authorities that's on the left, it indicates how many references to each opinion occurred. So that gives you some sense of how important those cited opinions might be by letting you know how many other citations those cases have. And then on that right-hand side again, similar depth of treatment information is provided in the little gray box below each opinion, letting you know how many references to our case are contained therein. Right? So that's what you can do today. But as I said, we're not satisfied. We want that sentiment analysis. So next slide. Why should it be open, right? Why should it be like everything else we do, free and available to the public and available to startups to leverage and so on? I think this being able to validate if a case is still good law is just essential to legal research, right? It is one of the most important things that just gathering together all the documents doesn't solve. So it's important. And then if we make it open and give it away to the world like we do everything else, then it's going to enable competition, right? And it'll help with this access to justice problem. It'll be more widely accessible. Everybody will be able to get their hands on this important legal research tool. So if it's easy to use, if it's affordable, hopefully it helps bridge that access to justice gap. But then another question I like to pose is just like, well, why should high quality legal research tools only be available to those who can afford to pay? Like that, as Anna mentioned, if 1 out of 15 Americans are visiting the LII to check out what they have, there's a lot of need out there. And there's also a lot of need that from people who can't afford to pay. And so I don't think they should get second-class tools, right? I want us to build tools that are feature competitive with the best things that are out there. That's hard, but it's about to get easier, I think, with the advent of machine learning. So I've tried to just pick one or two things, right, that Free Law Project has worked on over the last 10 years to tell you something about what you can do today, right, with the things we've done. But I'm going to leave it to Mike to look to that future, like ways that you could get involved and the other things that we're hoping to develop as time goes on. Thanks.
Thank you, guys. What a great thing to follow and what a great lead in. I'll just introduce myself real briefly. I'm the executive director of Free Law Project and one of the co-founders along with Brian. I've been doing this for a long time. I'm not a lawyer. I started on the technology side. I relied on Brian's expertise for a lot of that. But over the years, increasingly people think I am. I've been in the space for quite a while now. So I want to spend the remainder of our time together talking about action items that courts, individuals, and organizations can do to encourage innovation in ways that lead to a more equitable justice system. And I think as we've been talking, each of us has come back to that. It's not about data for data's sake. It's about data for justice. And I want to drive that home. And I think I'm probably preaching to the choir with some of you. But if you're not on board yet, I hope by the end you will be. So that having been said, let's change gears a little bit. And I want to talk about the very exciting topic that is procurement. If you're not familiar, procurement is the way that courts and other government bodies get stuff, whether that's chairs or software. And if you are familiar, you know how impactful good procurement practices can be. A pattern in government software procurement is to model it after the stuff procurement. You need chairs, so you write down how many you need, how big they are, how they work, all the details. You have people make bids, and before you know it, you got some chairs. Great. That doesn't work with software. It's vastly more complicated than purchasing stuff. Unlike chairs, for example, you often don't know what you need or what's available. Your staff is probably not great at speaking software lingo. It's just vastly more complicated than a lot of the other stuff that gets procured. And the result is that courts and other government bodies make extremely long procurement documents, leading to long procurement processes, leading to long software development cycles, leading to big bang deployments where a huge new system comes online, usually some number of years down the road. And I'm guessing this sounds familiar to a lot of us. We hear about it in the news. If you're in the government or in the courts, you've experienced this. And just to drive this home a little bit, we completed Freedom of Information requests for the 5 most populous states to get the contracts they use for their case management systems vendor. And one we got back was from Texas, a big state, admittedly, but they pay $18 million a year for their system. That's enough to pay, just to put this into sort of concrete terms, that's enough to pay 120 people $150,000 every year. And remember, this is for a system that their vendor sells to many states. I can promise you that if 120 people were working full-time on your case management system, not using it, maintaining and building the system, something is terribly wrong. The math just doesn't add up. Think about what other things you could do with that money. And better procurement practices can help with all this. So I'm sure nobody came here for a procurement speech, but it is an important topic. And there is a movement spearheaded by the federal government called Agile Software Procurement. It can really help. It has logged some very big successes. The federal tax court recently used this approach to build in-house a brand new case filing and management system. And, you know, like the slide says, you can make a solicitation that's 12 pages, write in an afternoon, and kind of get to work. I'm not the deepest expert on this. It's a big topic, but there are some good references for this. So here they are. Our slides will be available after the talk, and I wanted to put these in here for folks to read. This can save you millions of dollars. So these are important links. Let's move on. The next thing I want to talk about are a few things that federal and state judiciaries can do or not do to make open public access a reality. And again, this is not just a fun theoretical ideal. This is important. Open data leads to fair innovation, which leads to equitable tools. So here are a few things that courts can do. If you administer PACER, you can start by joining our movement to make it free. I know judges and court staff can't usually get involved in politics, but there is a bill in Congress, the Open Courts Act, that would create a new free PACER system. We hope everybody here will support the bill however they can. Might not be easy, but we hope you'll get behind it. That's going to take time. And so until that happens, there are some simple changes we hope courts will make to provide better access to the content. For example, in the PACER system, there is a checkbox that clerks and judges can click to say that they are uploading a decision into the system. Click the box. We have done an analysis to see which courts are good about clicking it, which ones are not. There are definite differences from jurisdiction to jurisdiction. So please do click the box. Second, every PACER system or CMECF system has an RSS feed. Please turn it on. This is a recommendation from the administrative office, and that would provide a list of every filing in the court so that people can get things like daily awareness alerts that Brian mentioned. Third, think broadly about fee waivers. We hear horror stories from academics all the time about how challenging it is to get fee waivers, how carefully they have to refine their requests. Just open it up. Be liberal about that if you can. So that's all inside of PACER. To those who that applies. Outside of PACER, there's a few things courts can do too. First, don't charge for public access to information. If you're making a new system, don't make it pay to play. Get an allocation from your state or federal budget and build the system you need. We don't charge people to walk into court. We shouldn't charge for access to information. Let's just stop doing this. Second,
Michael,
if you're building a system,
forgive me,
yeah,
can I get you to repeat the name of the bill?
It's the Open Courts Act.
Thanks so much. Forgive me.
Yeah, no problem. So second, if you're building a system, think about data access as a primary goal. Don't block scrapers, don't use CAPTCHAs. Please do provide an API. If you can't do that, make the HTML easy to scrape. Make your IT staff accessible to data aggregators. I can't tell you how many times we've tried to contact IT staff about a problem in a website and just struggled to do so. Finally, if you have mailing lists that you use to send your data to publishers or out into the world, put that list somewhere on your website so people and organizations know it exists. Allow organizations like Free Law Project to sign up and get those emails too. Treat us on an equal foot. And while we all do this, we hope everybody here will embrace Recap, like Brian was saying. We encourage you to do so. It's got 28,000 users. It only takes a minute to install, maybe even less. No configuration. If you use Pacer, we really encourage you to use Recap. So that's that. I want to talk a little bit more about neutral citations that Brian touched on earlier. You may have heard of these as universal citations. Personally, I think of these as the people's citation, not that it needs more names, but I think it's a good metaphor for the change that we're looking for here. So the way these work is actually quite simple. It's a simple citation for every decision. The court creates it at the time of publication on its website. And courts start using paragraph numbers to accomplish pin cites, because otherwise, how do you know what page something is on? On the right, you can see an example here. 2003 ND 140. That's decision number 140 from North Dakota Supreme Court in the year 2003. It's that simple. These have been used now since the 1990s. There's over a dozen states that are using these citations already. And I know that this topic can seem to be a little bit far out in the weeds, but just to sort of impress upon everybody here how important citations are, and how strange it is that legal ones are so difficult to obtain, I just want to drive this point home by saying that in the past, citations have been the subject of a lot of litigation. West has worked hard to keep citations from being copied and out in the world. They derive enormous value from these by keeping this data in their system and not out in the world. So we encourage folks to grab these slides, reach out if they're interested. We'd be happy to talk to you about this. It's pretty simple. You can see sort of in the fourth quadrant on the slide, you know, how to do this. It's kind of a 4 or 5 step process. It's really not that bad. There's more you can do. This is a lot of pie in the sky stuff. Some of it's pretty hard to do. Making Pacer free is not going to happen overnight. We've been working on it for years. But I want to give a concrete step here, another concrete step that courts can do. If this all seems a little overwhelming, or putting your data online with an API seems too difficult, we can actually solve this for you. We've done this for a number of courts so far, and we do this with court portals. So the way this works is we make you a little portal on our website, courtlistner.com. Your staff uploads decisions into the portal each day. That's the picture on the right. They kind of type in whatever data is necessary. On your website, you link to the portal and you say to the members of the public, attorneys, everybody else, here's a nice search access. And the result is that your decisions are automatically in an open, searchable, API accessible system with neutral citations affixed to them. So if any courts are interested in this, let me know. Happy to hear suggestions, ideas, questions, all of that fun stuff. And kind of expanding one more time from there, the portal is one thing, but we want to go further. And in the beginning of this year, we began researching the creation of an open source e-filing and case management system. we've been sort of looking at that problem space now for the better part of a year. And we're figuring out what to build. We're looking for court partners that are interested. The idea here is to come in, figure out how we can make things better for filers, make it better for court staff, and provide better access to the public. So if anyone's interested in that, it's a big initiative we're working on. We expect it to start small and slowly grow. So we'll probably start chipping away at that soon. And looking for partners presently. So I hope folks can reach out about that. So to wrap up this presentation, I just want to reiterate that there's a direct line. This is the third time I've said it, probably the fifth time today, from data availability to justice. When the data is available, tools like case law research, citators, and all the innovation we're seeing with AI, all of that becomes better and more equally accessible. We at Free Law Project are doing what we can, like Brian showed, to gather data, make it available to as many people as possible and organizations. But the work is hard. Just creating that list of reporters he showed took months of human labor. We need all the help we can get. So after more than a decade doing this work, we see two paths before us. In the first path, the data is freely available. A competitive ecosystem of legal technology solutions exist for courts, attorneys, members of the public. Innovation is flourishing. The tools are widely available, and legal research in America is an egalitarian point of pride. Those who need to use the justice system can do so effectively and fairly. That's one path. On the second path, a small number of companies own the law. They have a most favored nation relationship with the courts. Legal tools remain expensive and inaccessible to self-represented litigants, to attorneys, and to others. Those that can afford good tools are an advantage over those who cannot. Exciting developments in AI create superpowered tools that those with money pay for and use. Those without many resources, they muddle through. These two paths couldn't be more different. In a lot of ways, they begin with data and information. We're asking for everybody here to help make this first future the reality we choose. And please consider how you can help and join us in this work. With that, thank you for coming and thank you for your attention. And we'll open it up to any slides that are in the chat or any questions in the chat. Thank you.
Thank you. And I think I'm speaking for all of the stunned people in the audience to say, what an overwhelming project and what a way to do it. Are there courts that have best practices if a court wanted to sort of follow a lead? And I'll turn that to Michael first, if I could. Is there a court that you feel like, if I were trying to achieve these goals, here's a place I would look at?
Yeah, that is a great question. And I have to admit, it's not something I've analyzed carefully. There are definitely
That
courts
would be
that
the
are...
only thing you have not analyzed carefully then in the entire world.
I think it depends on which aspect, right? Like, for instance, for neutral citations, something we talked about, I always like to praise New Mexico because many years ago, they adopted neutral citations. They created a table that shows you how to translate all the old citations to the new system. So now they can have one unified neutral system for everything. And they've been doing it for years, chugging along just fine. It's a perfect example of a nice sized state with both a Supreme and Appellate Court that adopting this system, and it's working. The sky has not fallen, right? So it can be done. But on other aspects of this, there certainly are, when we're crawling all the court websites, some that are more cooperative than others. I think we know who we might want to put on the naughty list more so than we know.
That was not my question.
Yeah, Mike, can you think on other aspects, which ones are really...
Well, yeah, what I was going to suggest, Harvard, when they did they went and scanned their entire law library, and they made this clever agreement with the funder of the scanning, which is a startup, that any court that met some minimal standards would get the benefit of all that scanning immediately rather than waiting so many years. So they developed this little framework that was actually in their contract. And, I think it was, neutral citations, publication of decisions on websites, scrapable, and, a handful of other little things like that. So I think that's where I would start, is sort of like that's a pretty good framework for, checking the boxes. And I think they also went and figured out who was checking them.
Oh, thank you. Anna, anything that you would like to add to that conversation before we move to our next question?
I would just add that it's really it's a delicate area to call out courts for both praise or for the naughty list, but it's so surprising to me that we're still talking about free access to primary law, and hopefully we've found the way to communicate where we're at with primary law data at this point.
Oh, thank you. And I only meant to, I didn't
Yeah.
mean to sort of good list, bad list.
No,
Just,
I know,
want to
I
do
know.
something. What else is there? In case
Right.
anyone is listening to me. I love the court.
I know.
So this smart group has already answered some of the questions in the chat. How can we find out how you're gathering information on our specific court's opinions? Brian says, sure, Mike at Free Law would be the place to start. And then we have a question. Have you considered working with the Department of Corrections to make sure you have the proper settings features so it can be used by inmates for those who are incarcerated? There's a push to introduce the Prison Libraries Act in the new Congress.
Yeah, I'm not familiar with the Prison Libraries Act, but I'll check that out. I don't know if the other speakers are. But yeah, this is something we've definitely been thinking about. It's a tough one because you got to get the funding to do anything, in all honesty. And funding things for prisoners is a tough one.
Mhm.
It's also an area we don't have a ton of expertise, but we are talking to other organizations that are looking at this space, and it's definitely an area we feel needs more help badly, and we would love to do more there.
So if any of our wonderful questions are suggesting you're not doing enough, that is not the intention of the suggestions. It's like, wow, these great things are being done. How do we find out a little more of them? And then toward that end, are there plans of augmenting court listener with state court records?
Yeah, who asked that one? Sasha asked that one. Speaking of our naughty list. Um,
Wait, is that Sasha or the state? I'm really intrigued about that.
So yes, that's something we've wanted to do for a long time. It's incredibly hard. You're looking at, paying a developer or 2 or 3 for about 6 months as sort of your starting place.
Well, clarify, Mike, right? The difference here between
Sure. Yeah.
We from the very beginning had thousands of state court records at the Supreme Court and appellate level. We've always collected state materials.
That's right. Yeah. Yeah. So I'm speaking about, and I'm interpreting the question to mean the filings, going beyond just case law and also doing all the filings. So that's something, we would love to do. It's really hard to do, as we've learned from doing Pacer, but it's a great thing to do and impactful. So yes, we would love to. No concrete plans at the moment.
Okay. So I am grateful on behalf of the audience. I'm grateful. Any closing words for the good of the order? I'm so grateful that the slides are coming because hugely helpful. And while the 3 of you are quite familiar with what you're talking about, this was, somebody just wrote in the chat, it was eye-opening for me. I'm very grateful that this good work is being done. But any final words?
I'll just say thanks to my co-presenters for their time, and like I learned so much from being able to present on this, and this won't be the final word. It's like more of the beginning with the data to justice pipeline and working with different audiences and groups to really get the word out on how we can reframe primary law in the digital environment.
I think I would add, when Mike closed by asking everybody to do what they could to support us. And when a nonprofit asks for your support, everyone assumes that that means financial. And certainly we have a donate button, go to free.law and do that if you can, right? But there are actually so many other ways to get involved that a lot of people do. I mentioned that all our software is open source. People who are developers can help. Students who need a machine learning project, holy cow, there's so much low-hanging fruit with the developments in technology, right? And we're sitting on this giant repository of data that's just asking to be worked on. So there's so many things that people could do to get involved in, and we'll take all of those.
Excellent.
Yeah. I'll just say, thank you everyone for coming and for listening. This is a big space, and if anybody's interested in talking more about it, that's what I do all day. I had 15 minutes for my piece, so I could go much longer, and I would love the opportunity to do so.
And maybe if I heard it several times, I would get it in a better way. I am so grateful to the three of you. I'm so grateful to my partner in crime, Justin, and I'm grateful to the audience for your interest, and can't wait. As sort of a minimum standard, talk about low-hanging fruit. I think you've raised everyone's antenna about these issues. That by itself is really helpful. Professor Russell, when you're scouting other fantastic faculty, keep Berkeley Judicial Institute in mind, because this was a really fun hour. Thanks to all of you.